Hi, folks, and welcome to your video on employment law basics. We're covering workers' compensation and unemployment insurance. This video is hosted by the Cultivemos Legal Cohort. You'll find our logos above, and I'll get to our names at the end. My name is Rachel Armstrong. I'm the Executive Director of Farm Commons. I come from a long line of farming ancestors, and it is my pleasure to provide this information for you today. My organization is Farm Commons, and our mission is to empower agricultural communities to address their own legal vulnerabilities within an ecosystem of support. We produce educational resources like this video. We also write a lot of guides, host in-person workshops, webinars, we have a podcast channel, and we answer questions at our website. We believe that the best solutions for legal challenges are made by and for farmers in their communities. So we do a lot of leadership development to help make sure that farmers have the resources they need to step into leadership on these issues. We're also a membership organization. I can tell you more about that at the end. Now, today we're going to be talking, as the title indicates, about workers' compensation and unemployment insurance. And I'm going to begin with workers' compensation. So this is probably a familiar term to you. Perhaps a previous employer provided that coverage, or you've known folks that may have made a workers' compensation claim. As a business owner, maybe you've carried it in the past or are considering getting it in the near future. Whatever your experience may be, workers' compensation plays a role in the farm business. Here, I will explain how workers' compensation functions, when it's required, and how to navigate the thresholds and requirements for carrying it. Now, keep in mind that what I'm saying here is accurate here in early 2024, and that laws may change if you are watching this video after this time. Also, keep in mind that this video is provided for educational purposes to help you understand generally how the law works and how to consider your obligations. We are not giving you legal advice or telling you what to do in your situation because we don't know your situation. So keep that in mind throughout the video. Okay, let's start with the why. Why workers' compensation, which I'm going to use the initials WC for going forward. Well, it sounds like a good idea, right? This is insurance that provides coverage for people who are injured in the course of doing their jobs. I think most people can get behind that. Sounds like a good idea. But employers also know that it can feel like another expensive obligation or a bureaucratic hurdle to overcome as an employer. From the business's perspective, what's in it for you? Well, we do have a helpful secret to share here. Who does workers' comp really benefit? Well, let's take a look at who created it. Workers' compensation was actually created primarily for the employer. Yes, employees do receive benefits from workers' compensation, and we'll get to what those are. But it's important to point out right away here that workers' compensation was created for the employer. So even though the employer isn't the one who's receiving benefits, why were they the ones that that demanded the creation of these programs? Well, to understand this more fully, let's take a step back in time. So back in the old days, before workers' comp existed, employees who were injured doing their jobs often sued their employers for unsafe working conditions. Employees went out, found an attorney, made their case, went to court, hoped for a favorable judgment. And at the same time, employers were spending lots of money defending these lawsuits, paying out large sums in settlements and judgments. It was unpredictable. Owners and employees did not know, what the outcome would be. Employers didn't know when a lawsuit would be filed, couldn't plan for these things, couldn't budget for the financial consequences, being unsure that what a jury would find for an award. Unpredictability is bad for business, right? And so businesses started working with legislatures to find new and creative solutions to address workplace injuries in a comprehensive and predictable manner. And that is what led us to workers' compensation. Wisconsin became the first state to pass a workers' compensation law in 1911. By the time 1948 rolled around, all states had put in place a workers' compensation program. What workers' compensation did was eliminate the unpredictability of lawsuits. Workers who were covered under a workers' comp policy could no longer take their employer to court to sue for their injuries under what's called tort law. The injured worker, their recourse now was to go through their state's workers' compensation administrative procedures to seek financial compensation for their injuries. Now, you'll notice that I keep talking about states, and one of the important things to note here is that workers' compensation is created and regulated by state law, and every state has different rules for when and how to get it. All right. So let's talk about now how the workers' compensation system is used to compensate workers. It really is quite different than the traditional tort system, you heard me use that word before, of assigning responsibility for injuries. There are no courtrooms and lawyers making a case for negligence or blame. The employee makes a claim that they were injured during the course of work, and compensation is given if it is found that the injury indeed occurred in the course of their work. And that's that. Now, of course, I'm oversimplifying it a bit. There can be a host of issues that come up around workers' compensation, such as whether the injury really was covered and if there is even an injury at all. But the point is that workers' compensation is what is called a no-fault system. It is meant to provide financial compensation to the employee, whether or not the employer was negligent or did anything wrong. This eliminates a lot of unpredictability inherent in these cases for the employee and the employer alike. The employee can be assured of financial compensation for injuries, and the employer can rest easy knowing that their employee is taken care of and it's not going to bankrupt them in the process because they know that the workers' comp fund is covering them, assuming they paid their premiums, of course. So predictability is the name of the game with workers' compensation. Now, let's be completely honest. In some cases, the employee might lose out with workers' compensation on some benefits that they might have gotten. So, yes, we are assured that injured folks who are injured in the course of their job will be compensated, but going into a courtroom can sometimes give you the promise of a windfall. You might get a lot of money as a way to punish a bad employer. So if there's a truly terrible boss who maintains deplorable working conditions, really hazardous workplace, the employee can't punish them and get millions to, in compensation for that individual being a bad boss. So no windfalls here. And let's also talk about the role that OSHA does and is supposed to play when it comes to workplace safety. To go after bad bosses, folks who maintain terrible working conditions, employees have a remedy through the Federal Occupational Safety Hazards Administration, or OSHA. OSHA sets workplace standards, and if an employer is not meeting them, then the employee can complain to OSHA and an investigation would proceed. OSHA also conducts their own investigations to proactively find if workplace conditions are hazardous. However, in the farm context, this is not always the case. Although federal OSHA does apply to all employers, OSHA is currently exempting small farm operations from enforcement. So farms with 10 or fewer employees who do not also house workers are exempt from enforcement. So, this is a technical clarification, but note that the exemption is only from enforcement. OSHA does technically still apply to all farms, and the prohibition on enforcing it against smaller farms may change in the future. But for now, that is the case when it comes to enforcing safety standards on farm operations. Okay, so now that you know more about the whys and the whos of workers' compensation from the employers and employees' perspective, let's turn to what an injured employee actually gets from this program. In terms of coverage, workers' comp will pay injured workers' medical bills. It will also provide compensation for lost wages when they cannot work at all because they are too injured to do the job. And it will also cover wages and transportation from time off of work to go to doctor appointments. Workers' compensation also provides benefits, or what might be called awards, in the form of a flat rate financial compensation for more serious losses like losing a finger, a limb, or, God forbid, the loss of life. Now, to most farm owners, the question becomes, hey, am I required to carry this? Do I need to buy workers' compensation? Now, generally, every single business is required to carry workers' compensation, except for some farms. Some farms do not, depending on their size and location, have to carry workers' compensation. So, of course, you're wondering, well, what about me? We've got some answers. These states require all farms to carry workers' compensation, just like other businesses: New Hampshire, Massachusetts, Pennsylvania, New Jersey, New York, and Connecticut. Now, I'm limiting myself to the Northeast. This is a video for the Cultivemos community, which is centered in the Northeast United States. If you happen to be outside the Northeast region, or you are curious, you can definitely go to our website and access what's called the Selected Essentials in Farm Employment Law. We have one for every state. It details the exact rules for workers' compensation for agricultural businesses. So those 6 states require workers' compensation just the same as any other business. Delaware does not require any farm to secure workers' compensation. For other states, it's a little more complicated. These states require farms of a certain size to secure workers' comp. In Vermont, when the payroll is 10,000 or more in a calendar year, the business must secure workers' comp. In Rhode Island, when employees number 25 or more for 13 consecutive weeks. West Virginia, when employers number 6 or more. And Maryland, when employees number 3 or more, or the annual payroll is 15,000 or more for all full-time employees. Then in that case, purchase workers' compensation. These things can be complicated. And again, even if you're in one of these states, I do recommend accessing our Selected Essentials in Farm Employment Law for more details. That leaves out Maine. Maine allows farms to choose workers' comp or employer's liability insurance, so long as it meets certain thresholds for the value of that insurance and the coverage provided. So you're going to have to look that one up on our Selected Essentials if you're in Maine for more details. Do note, though, and I saved Maine for last to try to illustrate this distinction. So Maine is allowing farms to choose workers' comp or employer's liability insurance. If you choose employer's liability insurance, do note that that means that the injured individual can sue you, and you have insurance for if and when they do, but there's still, the potential for a court process, for the placing of blame, the investigation of your circumstances and conditions that led to that injury. So they're presented as an either or in this case, but don't think of them as equal. You got to measure for yourself which one of these is right for you. Okay, now I got to make an important transition. These rules that we have been offering about workers' compensation, and I'm just going to click on some of these slides again. So here, when payroll is 10,000 or more, employees are 6 or more, blah, blah, blah. These are the farm rules. These are for farm businesses. You remember, only these 6 states are the ones that follow the same rules as non-agricultural businesses. So knowing now that we have specific rules for agricultural businesses, we got to ask ourselves, what is agricultural? All right. If you are assigning non-agricultural labor to your workers, you may need to follow non-agricultural rules. So the exemption from workers' comp doesn't necessarily attach to the business. It attaches to the kind of labor you are assigning. So be aware, if you assign non-agricultural labor, pay attention to that non-agricultural rule. And generally speaking, those require that workers' compensation be secured as soon as you have any employees. But then that begs the question, what is agricultural labor? What is not? States don't make this question easy to answer. The details, you might find subtleties and some contours laid out in case law, which means after people sue each other and they start to argue about it in court. You may find some policy opinions issued by the enforcement agencies at the state level. But again, these things can be hard to find, hard to interpret. The Farm Commons has produced a guide, the Farmer's Guide to Hiring Obligations, that does have a chapter in it about the definition of agricultural and non-agricultural labor. It is an interpretation of federal rules that are persuasive to the states. So generally speaking, I can tell you that if it is the raising of livestock, the cultivation of crops, it's probably agricultural labor. The farther you get away from that, the more it may not be. So even things like making deliveries to restaurants through direct-to-consumer sales, hosting tours and events on the farm, working entirely in a pack shed rather than going out to the field to get those harvested items, all of that starts to cross the line into non-agricultural labor, and regular rules apply. All right, so let's say that you are not required to get workers' compensation and you choose, and you're wondering what to do if you aren't required. Well, the first thing is you can still buy it, even if you're not required, and there are good reasons for doing that. The predictability of the program, guarantee coverage for workers injured in the course of their jobs. But if workers' comp is still not the right choice for your operation, you do need to buy liability insurance that covers workers. Remember, if you don't have workers' comp, your workers can sue you if they are injured. So liability coverage for that is really important. These insurance companies, when you buy a policy, will provide an attorney who can go to bat for you, handle your case. And if in the end you are found liable for the injury, insurance coverage will pay the injured person up to the coverage limit. Keep in mind, though, that this type of insurance can be hard to find. Where every other business except farmers is required to buy workers' compensation, there is not much demand out there for liability insurance that covers workers, because nobody else is trying to buy this. If you do need to buy a worker or liability insurance for workers, the best thing to do is ask your peers. Now, how do you go about getting workers' compensation? Generally, you buy it from a private insurance agent or from the state agency itself, depending on how your state's program works and whether or not the private insurance companies have a policy for you. To get moving, as a farmer, the best thing to do is call your insurance agent and say, hey, I'm looking for workers' comp. Do I get that from you or should I go to the state? So let's also touch on some equity considerations that are at play with workers' compensation. This is a system that has the potential to be abused by bad employers who don't honor workers with safe working conditions. Bad employers can get workers' compensation, and employees injured under their watch have to take whatever workers' compensation provides and not more. So maybe you've been driving down the highway and you've seen billboards for attorneys who specifically take on workers' compensation claims. That might be confusing now, given what I just said about how workers' compensation avoids lawsuits against the employer for liability for employee injuries. Well, that is true, but at the same time, the employer and their company can delay or deny benefits that a covered employee is entitled to. You can see how, if you have a bad employer, the deck can get stacked. The employee can't sue the employer for injuries, and they might need an attorney to help them lay claim to their benefits. So it can be a sticky situation. Needless to say, running a safe farm with healthy working conditions is a core part of being an equitable employer, whether you offer workers' compensation or not. All right, well, that concludes our section on workers' compensation. And next up, we have employment insurance. Now, this is also called unemployment tax. Tax, insurance, two sides of the same coin. I like to use both words. Unemployment insurance tax. All right, for anyone who's unfamiliar, unemployment insurance is a federal and a state program that provides benefits to people who lose their job through no fault of their own. The program is funded by collecting money from the businesses who employ workers based on their total wages paid. So this is different than income tax or other forms of payroll tax that you might be used to. Income tax is taken entirely from the employee's earned wages. Unemployment insurance is paid by employers, and employers are not allowed to take the cost from the employee's wages. This is an additional cost of having employees that goes above and beyond paying wages. A few states do collect some tax from employees, but that is uncommon. The main thing to note here for our video, though, is that many farms have an exemption from unemployment insurance tax. Farm businesses often do not have to pay into the unemployment insurance program. That also means that the employees of businesses who don't pay into the system cannot access the system. So most farm and ranch workers can't receive any unemployment insurance benefits when their work ends. They're no fault of their own. Some agricultural businesses choose to pay into the program if they want, and if they want their employees to have access to these benefits. The tax rate that a business pays depends both on the total payroll and on their usage of the program. If the business's employees apply for and receive benefits under the program, that business's rates tend to go up. And this is to encourage businesses to provide stable, predictable employment that benefits workers. Now, of course, stable, predictable employment is a challenge for many agricultural employers. Hence the exception, perhaps. All right, so with that background out of the way, let's discuss when you do and don't have to pay unemployment insurance tax. Federal law first. Also called UI. UI tax is owed if either of the following occurs. If you reach $20,000 in wages paid in any calendar quarter of this year or of the previous year, you must start contributing. In the alternative, if this year or last year you had 10 or more employees at least some part of the day, whether or not at the same time during any 20 or more weeks, then you must also start paying into unemployment insurance tax. Okay, so if, for example, you have 10 employees that work every Monday for 20 weeks in a row, you have hit that latter threshold, even though you're probably not anywhere near 20,000 in payroll in a calendar quarter. Keep in mind that these thresholds kick in automatically as soon as the 20,000 threshold or the 10 employee threshold is exceeded. But then after the obligation kicks in, it sticks around for another year, even if your payroll numbers, payroll volume or number of employees drops again. Now, there's no way to make it easier. That just is what it is. You may need to listen to this again or go check out the selected essentials in farm employment law for your state and study up on these mechanics. Also, your payroll provider, if you use a payroll company, can help you understand these thresholds as well. Okay, if we're now that let's be very clear that that is the agricultural rule, this 20,000, this 10 employees. If you are assigning non-agricultural work, you may need to follow the non-agricultural rules. And federally, that means you start paying when your total payroll equals $1,000 in a year. So it is a much lower threshold for non-agricultural work. States also have their own unemployment insurance tax programs. The Northeastern states all follow the federal threshold for the state program, except Rhode Island. There is no exception for agriculture. In Rhode Island, you pay into the employment security tax, as they call it, when cash wages total $1,000 in any calendar quarter. Be aware if you're assigning the non-agricultural labor, follow the federal non-agricultural rules. Federal unemployment tax is owed when the farm paid wages of 1,500 or more in any calendar quarter for the last 2 years, or had one or more employees for at least some part of the day in any 20 or more different weeks in the last 2 years. All right. So, unemployment insurance. I can't say enough. Payroll, a qualified payroll processor that is used to farm businesses and knows the rules can really be tremendously helpful to help you monitor these situations. All right, so that's what we've got for you on workers' compensation and unemployment insurance. If you're intrigued, you want to know more about how farm law affects you, consider taking our Discovering Resilience course. It is a multi-week course. You'll learn the 10 best practices of a legally resilient farm, create a customized action plan for your own legal resilience. You can take it on your own time or with a cohort of peers. We have a ton more information at our website: an advanced farm employment law course, individual guides on farm employment law, our Farmer's Guide to Hiring Obligations helps you define agricultural labor, define a work week, lots of other complex questions. We also handle a lot of intriguing questions on our question and answer platform. Our resources are available under our membership program, which is what helps us maintain them and make sure that you are getting accurate, up-to-date information. It certainly does require a lot of time and expense on our part to maintain these resources, and that helps us with those costs. Scholarships may be available. Check this video description for more information, or of course, reach out to us, info@farmcommons.org. And this video is brought to you again by the Cultivemos Legal Cohort. Our members are Jackie Schweizler, Whitney Shields, Francesca Gallo, Sheila Marshman, and myself, Rachel Armstrong. Thank you for being with us today.